Members of the National Assembly will today vote on the motion of no confidence against Speaker Thoko Didiza. The motion was tabled by EFF leader Julius Malema in June this year. It relates to Didiza's stance to not oppose President Cyril Ramaphosa's urgent application in the Western Cape High Court to prevent the parliamentary impeachment process over Phala Phala matter to continue until the Section 89 independent panel report is reviewed. Now, to talk more about what today's motion of no confidence vote could mean for the National Assembly Speaker, Thoko Didiza, and the Parliament's parliamentary impeachment processes, we are joined by senior lecturer at the Wits School of Law, Shadi Maganoe. Great to have you. Thanks so much for your time to talk about this issue.
Thanks for having me, Lian.
So when we look at this particular issue, I mean, so much has happened in this no confidence speaker that was tabled by the EFF. This happened in June. A lot has gone on since then in relation to the parliamentary impeachment process over Phala Phala. Why does it still matter at this point?
I think it still matters because the vote of no confidence against the Speaker is not the same as the proceedings that are happening with the Phala Phala matter or the Section 89 impeachment committee. So this is a different, basically it's a different process. Yes, both are parliamentary processes, but this one is a different process. What the EFF is basically arguing is that the Speaker is not fit to be Speaker anymore based on the decision that she took during the whole interdict proceedings. So, but from the way I understand it, there's no rule that I'm aware of that says that the Speaker must automatically oppose every court application concerning Parliament, or that she is bound to adopt the litigation position taken by a parliamentary committee. You remember the reason we're here is because during the interdict proceedings with the Western Cape High Court, the Speaker filed a notice to abide, and she also provided an explanation of Parliament's position instead of opposing that interdict like the chair of that Section 89 committee basically did. So I think the fact that she chose to abide rather than oppose does not by itself make her it doesn't make her decision unlawful. I think the more difficult question is whether she exercised her discretion consistently with her constitutional responsibility to protect the interest and functioning of Parliament. And that's where the EFF's criticism comes in. But saying that she made the wrong decision or she made a wrong political or institutional choice is not automatically the same as establishing that she acted unlawfully or that she was biased in filing that notice to abide. I think the option to abide was one that was legally available to her, and she used it.
Yeah. I mean, the EFF alleges that Didiza acted contrary to legal advice. This is what they're saying. They're saying that Parliament responds that legal advice is not binding and that the Speaker also had to consider wider constitutional responsibilities. What would MPs actually need to establish today? Was it poor judgment, irrational conduct, evidence of actual partiality? What is it that they're looking for?
I think it goes to a similar process of a motion of no confidence against the president. They just need a majority. So what basically happened here is that the EFF is arguing that she was biased or that she made a wrong decision or a wrong political decision because she filed a notice to abide, and she seemed biased because she's a member of the majority party, which would be the ANC. So I think in this instance, the EFF doesn't need to prove much. It just needs a majority of the vote in Parliament to remove her as the Speaker of Parliament. So this is basically a process that will be dealt with by the Deputy Speaker because we still have a Deputy Speaker. But they don't have to prove much. They just need to prove, or they need to argue that the decision she made was biased and that for that reason she's not fit to be Speaker, and then the vote would have to be in the majority, or it would have to sway in favor of the EFF, and then the Speaker would be removed in that sense. So it's a similar process to a motion of no confidence against the president. They just need a majority. They don't need to prove much, which is different from the Section 89 committee, as we've seen. There you need to investigate. A report needs to be made before the National Assembly can decide whether to remove the president or not. So when it comes to a vote of a motion of no confidence, it's easier in the sense that you only require a majority to vote in favor of that motion, and then the person would be removed.
It's basically 50 plus 1. That's all that needs to happen today, in favor either way. Recently, the Constitutional Court denied opposition parties, including the Mkhonto weSizwe Party, the Economic Freedom Fighters, and the African Transformation Movement, leave to appeal that High Court interdict that halted public hearings of the Section 89 inquiry. Constitutionally, does today's motion have a standing?
It does have a standing, constitutionally speaking, because it's legally allowed. If you look at Section 52, it's Section 54 of the Constitution, which allows, first we start with Section 52, it allows the removal of a speaker by the Deputy Speaker through a resolution, which is basically what the EFF has used. And then similar to the provisions of Section 54, which requires a majority of members of the National Assembly to be present. So we only need them to be present. And then this rule is also substantiated by Rule 28 of the National Assembly Rules, which governs the removal of the Speaker. So it's constitutionally speaking, these are the powers that members of parliament have, or these are the powers that the National Assembly has. So it does have a constitutional standing because the Constitution and the National Assembly rules allows it. So if that vote happens and it's in favor of the EFF, the Speaker would have to be removed immediately from her office as the Speaker, and then it creates a vacancy in the office, but it doesn't create a vacancy in Parliament.
Here's another interesting aspect on all of this, and I know this has been a big talking point. I mean, today's sitting is actually a virtual sitting, and the EFF wanted this actually to be a physical sitting and raise the possibility of a secret ballot. Let's talk about this virtual sitting and the removal vote, legally adequate, and does the principle established in this 2017 secret ballot judgment extend to the removal of a speaker?
So remember that we are governed by a precedent as well, apart from legislation. So the UDM versus Speaker case basically created precedent as to how Parliament can conduct itself when it comes to votes. So they can decide to either do it through a secret ballot or to do it openly. But I think the starting point when it comes to that vote and whether it can be done virtually or not is that Section 52 of the Constitution that I just spoke about. So it provides that the National Assembly may remove a speaker or deputy speaker by resolution, provided that the majority of the members are present, and then when that resolution is adopted, right? And then you also see similar provisions in Rule 28 of the National Assembly Rules, and then it's also similar to Section 54 of the Constitution, which requires a majority of the members of the Assembly to be present when the resolution is adopted. The tricky part about the provisions that I just made is that both Sections 52, 54, Section 52 and 54 and Rule 28, sorry, too many rules, don't prescribe whether this must be in person or virtually.
Yeah.
We have evolved, right? So, for example, one could argue that you and I are together right now, or I'm with you in the same room right now, which is basically one of the points of contention for the EFF. So the EFF is basically making an argument that removing a speaker is more serious, or it's serious enough that members should be physically present. But legally, the question is whether the procedure adopted by the National Assembly complies with Section 52, subsection 4 of the Constitution and the applicable rules of the National Assembly.
Yeah.
So Section 52 requires a majority of the members to be present when the resolution is adopted. It doesn't explicitly say that that present must be that they must be sitting in the same room, or whether a virtual meeting would basically accommodate that requirement of presence.
Yeah, it's crazy. The thought of it is crazy. I suppose, as you say, things have changed, but no one believed in 2017 that this is the kind of thing that we'd be talking about when that was actually established. Just very quickly, I want to get a glimpse into what happens next. Let's paint a scenario and say that the motion actually succeeds. Does the Speaker automatically, obviously, have to step aside, lose that position as a Speaker, but does she also lose her seat as an MP?
So she wouldn't lose her seat as the MP, and her removal basically creates a vacancy in the office of the Speaker, like I said, but it doesn't create a vacancy in Parliament. So the Constitution provides for mechanisms that deal with that situation. The Deputy Speaker would act as Speaker, or they take the position of the Speaker while that office is vacant, and the National Assembly must then elect a new speaker among themselves. So Parliament continues to exist and perform its constitutional functions, and then the National Assembly would have to proceed to elect a new speaker in terms of Section 52 of the Constitution. And then the election of the speaker is presided upon by the Chief Justice or a judge that is designated by the Chief Justice. So there would be a change in who presides over the National Assembly, but not the institution itself.
Okay.
And then the speaker would basically go back to being a member of Parliament, because remember, the speaker comes from those MPs. They are the ones who chose the speaker. So because the ANC has put her in Parliament as an MP, then she will just be an ordinary member of Parliament, but she would no longer be the speaker.
Okay, well, there's that answer. Just finally, I think you've already answered it. The actual substantive review of the panel report is expected to begin next week, while the public hearings remain paused. There won't be any delays. You've already said that. No matter what happens today, Parliament will function. Everything's still in order.
Exactly. So the removal of the speaker doesn't change anything.
All right, we'll leave it there. Thank you. You've helped me a lot. I hope you've also given a lot of our viewers much more insight into what is going to happen today. That was Shadi Maganoe, who is a senior lecturer at the Wits School of Law, giving us some brilliant analysis on the members of the National Assembly vote on the motion of no confidence against the Speaker, Thoko Didiza. It happens today. We'll keep that live for you.